and EasyJet Airline Company Ltd.
Yes, it's coffee.
Good morning, my lords. I appear for the appellants, Miss Dore and Miss Bastilla. My learned friends, Mr. Tennant, KC, and Mr. Taylor, appear for the respondent, EasyJet Airline Company Ltd.
Yes.
Before we continue, my lords, I would quickly like to pass on my condolences to the family of the late Michael Duggan, QC. He was with Mr. Taylor as his junior. He was instructed on this matter on behalf of the respondent, but he sadly passed away on the 16th of September. So I'm grateful to
Yes, well, that is very sad news, and we were all extremely sorry to hear it.
I'm grateful for the indulgence of your lordships to permit me to do that. My lords, before I outline the issues that this court is being asked to consider and my submissions thereon, some quick housekeeping matters, if I may.
Yes.
Please may I check that your lordships have received 3 copies of the core bundle?
Yes, got a core bundle.
3 copies of the supplementary bundle?
Yes.
And in relation to the authorities bundle, there were 3 copies that were filed on the 3rd of October 2022. And these were lodged for the purpose of ensuring that the court had all the bundles that were required as per the listing window notification letter. But on the 26th of October, 3 bundles of authorities, the same bundles effectively, but they were certified by me. And they have an, do you have that? And it just says it as compliance with paragraph 29, some paragraph 5 of practice direction 52C.
Well, I've got a bundle which has 9 items in it,
And
which is Bott and then a lot of Phipson, Lipton and Joseph Constantine.
But at the front, on the front page of that, so on the index, it should say the certificate of compliance. Is that?
No.
I can pass up 2 spare copies if you want, but there was.
Well, if we've got, and actually I was going to make the point at some point that the cases seem to be internet printouts rather than copies of the weekly law reports, for example. Should be, as I'm sure you know, weekly law reports if the cases are reported.
Yes, so I just wanted to just point out that those were, if you had those various copies of the authorities bundle, that was why you would have them.
So we would have them if the later ones had come in. All right, well, you spotted the error and diffused the problem. But we don't have it.
No. Okay. And then there was 1 USB stick with each of the bundles on. Did you get that?
Yes, I think I did.
And then, if I may, just my skeleton, dated the 25th of July, 2022. That's also set out in core bundle at tab 14.
Well, I've certainly seen a skeleton argument in the core bundle. Yep. Yeah.
I'm grateful. My lords, we do have an issue, I think, in relation to the respondent's skeleton argument, if I may, briefly.
Yes.
So, in this case, the respondent did not file a respondent's notice. Therefore, pursuant to paragraph 13, subparagraph 2 of practice direction 52C, the respondent's skeleton argument had to be lodged and served in accordance with part 1 of the timetable in section 5. And if your lordships do need the page in the white book, it's page 1958 for the timetable. And it states that where a respondent has not filed a respondent's notice, the respondent must lodge its skeleton argument and serve it on every other party 35 days after the date of the listing window notification. Mm-hmm. The listing window notification letter is dated the 3rd of August 2022.
Yes.
Now, in line with the prescribed time limit, on the 16th of August 2022, the respondent, who at that point in time was represented by the late Michael Duggan, QC, and Mr. Taylor, filed its skeleton argument, and this is the respondent's skeleton argument that can be found at tab 15 of the appellant's core bundle. So I'll call this the original skeleton argument in May.
Yes.
However, on the 26th of October 2022, so Wednesday last week,
yes,
the respondent served my clients with a new and revised skeleton argument that's been written by different counsel, Mr. Tennant, QC, and I'll call this the new skeleton. And it appears to want to rely on this new skeleton, and I submit that your lordship should not permit the respondent to do this for multiple reasons.
Well, it seems to us that, frankly, there's been quite a lot of beating about the bush in this case hitherto, and it has taken some time for the real issue to emerge. It seems we do now know what went wrong with the submission of the automated thing which may or may not be a claim, to try and keep it neutral for the moment. which is that the details were correctly inputted, save for the booking reference, which whoever was filling it in, is it flight right or right flight, whatever they are, put in the flight number as the booking reference, and for some reason, therefore, that was not accepted by the EasyJet computer. And the short question which arises is whether the submission of an automated claim or purported claim, which doesn't have the right booking reference, counts as a claim for the purpose of clause 19.6. If it does, it seems to us that you win. If it doesn't, Mr. Timming wins. And it seems to us that that's a point we really ought to decide, rather than flapping around about who has the burden of proof when now the facts are known. And it's a short point, and possibly, depending on how often this kind of thing happens, an important point.
My lord, if I may, what I would say is about, I know that you said the real issue to emerge is that we now know what's wrong, that there was this purported error in the form, but I will come on to address you about that, but I would say actually this was new evidence that was adduced by way of the skeleton argument, paragraph 34 of the respondent's skeleton argument. We actually don't, what I would say in relation to this new evidence is actually we don't know if it's credible. We don't know.
Well, it's entirely credible, because you said, or somebody on your side said at an earlier point in the case, that the booking reference and the flight number are the same, and they're not. And that shows exactly what the error was that was made.
So what we said was the booking. What I would say so is that we actually have we don't have the evidence of actually what error was purportedly made. But I'll go into this submission, if I may, in a bit.
Mm-hmm. Yes. All right. Well, what are you asking us to do about the skeleton argument?
So in relation to the skeleton argument, I'm asking you to not allow the respondent to rely on it on the basis that the new skeleton was not filed within the prescribed time limit set out in paragraph 13, subparagraph 2 of Practice Direction 52C, and the timetable in section 5. Further, no application was made by the respondent under Part 23 to obtain the court's permission in advance of today's hearing to rely on the new skeleton. In addition, no supporting witness statement has been provided to explain why the new skeleton is necessary, particularly as the same junior counsel is being used, or why it could not have been lodged earlier, given that it's been more than 5 weeks since the death of Mr. Duggan QC. Third, the new skeleton is not a replacement skeleton argument. That would only be one that's been amended in order to include cross-references to the appeal bundle. Rather, this skeleton doesn't do that. It seeks to put forward, I submit, new arguments.
Well, I'm afraid we're against you on that. We will allow the respondent to develop the arguments in his skeleton.
I'm grateful.
If there are any consequences of the lateness, you can address us on that at some later point, but at the moment it seems rather unlikely that that will be the case.
I'm grateful, my lord. My lord, I submit
Excuse me. Yeah, no, my lord reminds me that if you have a point that there is something in the skeleton which is not supported by evidence, that's a submission which is open to you.
I'm grateful. My lords, I submit that essentially in this appeal there are two central issues that we're really looking at. As your lordships will have seen from the transcripts.
Just while we're on housekeeping, I mean, are you seeking to rely on the letter that's the subject of the application to introduce new evidence?
I will be, and I will address that. I will address that later on in my submissions, if I may.
Yes, all right.
Okay.
As your lordships will have seen from the transcripts, both judges in the lower courts have, in effect, and without ever having seen a copy of the online compensation form, which I call form, held that the reason for my client's compensation claim being dismissed was because the form that had been submitted had either not been filled in correctly, and/or was insufficient. Therefore, no claim had been submitted. Accordingly, I submit that the first issue for your lordships to consider is whether the purported failure to correctly fill in the form on the respondent's web portal acts as a complete defence, with the effect of such being that it bars my clients from bringing proceedings in the civil courts to claim for compensation for a delayed flight. And my lords, I submit that it does not. However, if your lordships are not with me on that and take the view that the failure to correctly fill in the form does act as a complete defence or bar, then I submit that the second issue for your lordships to consider is how to deal with essentially the evidential gap and the absence of disclosure obligations on the small claims track when parties are in a situation where one party does not and cannot have the one piece of paper or documentary evidence required to prove its claim, while the other party definitely does have it, with such having been evidenced by the opposing counsel's two skeletons, but that other party having failed to disclose or otherwise produce that one piece of paper or documentary evidence. If that other party, in this case the respondent, fails to disclose or otherwise provide this one piece of paper or documentary evidence, does this mean that my clients cannot obtain redress? And I submit at that point that that simply cannot be right or just.
Yes.
And that's an important point of principle that warrants consideration by your lordships. So, having outlined the issues subject to your directions, in terms of structure, I propose to first consider issue 1, and my submissions on this issue will cover grounds 1, 2, 3, 4, and 5 of the grounds of appeal. Then, to deal with issue 2, my submissions on this issue will cover the important point of principle as evidence, as well as grounds 5 and 6 of the grounds of appeal. Then I propose to deal with my client's application to reduce fresh evidence in the form of the letter, dated the 26th of April 2021, and then deal with the respondent's attempt to introduce fresh evidence through their skeletons without having applied for permission to do so, and then lastly, move on to my concluding remarks.
Right.
And the reason for my structures the reason for the structure I proposed is I intend to deal with the points of public significance first. And in terms of timing, I've discussed this with my learned friends. I propose to speak for at most 2 hours, if not shorter, and then my learned friends speak for 2 hours, and then 30 minutes for reply. It may be done more quickly. But if I may I proceed?
Yes. Well, I mean, the question whether filling in a form but getting one detail wrong qualifies as a claim or not seems to me to be a very short point indeed, whichever way it should be decided. You proceed.
Turning to issue 1, as I've already stated, the first issue is whether the purported failure to correctly fill in the form on the respondent's web portal acts as a complete defence, with the effect of such being that it bars my clients from bringing proceedings in the courts to claim for compensation for a delayed flight. And I submit that it does not act as a complete defence or bar for 2 reasons. Now, the first reason stems from the wording of Article 7, Regulation brackets EC number 261/2004, i.e. the regulation, as well as the conditions set out in case law that must be fulfilled in order for an air passenger to be entitled to claim compensation for a delayed flight. Now, if I could ask your lordships to, in the authorities bundle, please turn to tab 1, page 2. And that should be the judgment given by Lord Justice Lewison in the case of Bottom Coast Solicitors Limited against Ryanair DAC.
Yes.
And may I have permission to dispense with a full citation?
Yes.
Now, if I could ask your lordships to turn over the page to page 3, your lordships should see paragraph 6 of the judgment. There is a little...
I think paragraphs will be more helpful than page numbers, as
Paragraph
I'm not
6.
looking on the report.
Paragraph 6
yeah.
of the judgment.
Okay.
So in this paragraph, Lord Justice Lewison held, and I quote, "An air passenger whose flight is delayed for a specified period beyond its scheduled time of departure is entitled, subject to certain conditions, to compensation for a delay under the regulation. This regulation does not expressly provide for compensation for delay. then goes on to say, Article 6 of the regulation deals with the delay of a flight beyond its scheduled time of departure. And then goes on to say, but the Court of Justice of the European Union has decided that the regulation must be interpreted as if it did provide for compensation for delay. In any of these cases, compensation is payable under Article 7, subject to certain conditions.
Yeah.
So, concerning Article 7 of the regulation itself, it was amended by the Air Passenger Rights and Air Travel Organisers Licensing (Amendment) (EU) Exit Regulations 2019.
Well, there's no doubt, is there, that subject only to the question of whether they made a claim that satisfied Clause 19, the appellants are entitled to compensation for flight delay in this case.
So what I submit on that case is actually what we're looking at is whether this this form, whether if you do fill it in incorrectly or insufficiently, if that acts as a bar to you then pursuing compensation in the civil courts. And then if it does, what I was developing in my second submission, well then, and because the defendant, or rather the respondent, has tried to put forward the argument that it was insufficient or incorrect, it's bound positively to prove this averment. And we know now that the respondent does have a copy of this form, but simply intentionally or otherwise withheld it. And so, in relation to Article 7, if you could please turn to, it's tab 8, page 62 of the bundle.
I'm afraid I don't have tabs either. No doubt I would have had if I got the later bundle, but...
This is Lipton, is it?
It's Lipton. And there, if you, on page 62, you should be able to see paragraphs 71 and 72 on page 62 of the authority bundle.
Yes.
And then if your lordships could turn over the page, you'll see Article 7 as amended by the regulation. It provides, in relation to Article 7, right to compensation. Where reference is made to this article, passengers shall receive compensation, and then it sets out the various amounts of compensation that shall be given. Now, if I could please take your lordships back to paragraph 7 in the case of the judgment in Botton Code, which can be found on page 3 in the authorities bundle. Paragraph 7, your lordships, please.
Yes.
And there Lord Justice Lewison stated, and I quote, "The principal conditions, apart from the delay exceeding a prescribed length of time, which in turn depends on the distance covered by the flight, are broadly that the air passenger, in departing from the EU member state, the passenger is departing from an EU member state, or is travelling to an EU member state with an EU airline, and the delay is not caused by extraordinary circumstances. Compensation is in principle fixed by the regulation." And this was reiterated in paragraph 1 of the case of Lipton, which, should your lordships need the reference for, is page 45 of the authorities bundle, where Lord Justice Coulson states, "Passengers whose flights are significantly delayed are entitled to compensation under the regulation, and the only way the air carrier can avoid paying such compensation is by demonstrating this significant delay was caused by extraordinary circumstances." So,
which are not suggested in this case.
No, and so it's simply saying that actually the conditions that Lord Justice Lewison outlined have all been fulfilled by my client. So there was no defence in terms of extraordinary circumstances. So my clients were entitled to get compensation. And that's that point, so I'll move on to the second.
They're entitled, I think, they're entitled provided that they make a claim. I mean, that's the question that my lord's been trying to get you to focus on, I think. I mean, I don't think it's disputed that the underlying prerequisites for a compensation claim, insofar as them being on a flight which was delayed, travelling within the EU, etc., nobody's doubting those criteria. As I understand it, the sole ground for EasyJet's defence is that clause 19.6 of EasyJet's terms and conditions required a direct claim to be made, which may be made on the portal. And it said your clients didn't do that because, for one reason or another, the person filling it in on their behalf got some details wrong. And I think, so all the underlying stuff is, as I understand it, not in dispute.
So your lord, my lord, if I may, then I'll move on to the second reason, and that's that the case law doesn't establish that a failure to fill in the form essentially means that there's essentially an insufficient claim, or that it's a bar to bringing the claim for compensation. If I may move on to that, my lord.
Right. Well, don't we need to look first at clause 19.6? I think that might be helpful.
That will be in this.
All right.
In these sets of submissions. So if I could take you back to the case of Bot & Co, please. Paragraph 63 of the judgment, which you can find on page 15 in the authorities bundle.
Yes.
So in paragraph 63, Lord Justice Lewison says, I find it difficult to see how, this is Article 15, can outlaw a procedure devised by the airline for handling compensation claims, simply on the ground that it prescribes a process. That seems to be the view of the Civil Aviation Authority, whose advice contemplates that the passenger might have to fill in a standard form. In paragraph 65, he goes on to state the regulatory bodies encourage direct contact between passenger and airline. The Civil Aviation Authority, which is the national regulator, says on its website, if you believe you have a claim, you should contact your airline directly. Many airlines will have a claims procedure for you to follow. Often a standard form is available. If so, using it will ensure you provide all the information the airline needs to process your claim. So if I could ask then your lordship to turn over the page to paragraph 67. Paragraph 67, Lord Justice Lewison states, the European Commission gives similar advice. In its information notice to air passengers, it says, and I say that this is key, passengers should always seek to contact the operating carrier before considering other means to seek redress for their rights. And then further down the page, in the last sentence of paragraph 70, Lord Justice Lewison proceeded to state in his judgment, there's nothing obviously objectionable in policy terms to, and this is key, a clause which channels the complaint, at least in the first instance, through a process backed by both the national and the EU regulators. And in paragraph 71 going down, when citing the judgment of the lower court, it says, if a claim is rejected after the passenger applies through the online form or in correspondence, there is nothing to prevent the passenger from instructing Bot at that point, or indeed at an earlier point, provided simply that the passenger makes this claim initially directly with the airline. And then lastly, if I could ask your lordships to turn over to paragraph 72 of the judgment, where it says, if a passenger needs help in filling in the online...
Sorry, wait a minute. So 71 is a quote from the first instance judge.
Yes.
And he says at 72, I agree. So you're saying that Lord Justice Lewison is there saying that provided that the passenger's made its claim initially directly with Ryanair,
either through the online form or in correspondence, then yes, provided they've made the claim initially directly with Ryanair, then that's acceptable. And then in paragraph 72, Lord Justice Lewison goes on to say, if a passenger needs help in filling in the online form, there's nothing to prevent that. On the contrary, it's permitted. All that the passenger has to do is to press a send and submit button, and even that could be done by a third party, provided the claim is made in the name of the passenger. At most, the delay in processing a claim is 30 days, which is no longer than the response time that the airline itself requests. And then I submit that this is key after that. A passenger is free to process a claim in any way he chooses, with or without the assistance of third parties. So, my lords, I'd now invite you to consider my client's actions and how they align with paragraphs I've just quoted of the judgment of Lord Justice Lewis in the case of Bot & Co, if I may.
Mm-hmm.
So if I could ask your lordships to please turn to the supplementary bundle. And I won't give you the tab because I don't know if you'll have it, but in pages 9 to 11.
Yes.
So at page 9, we can see, your lordship should be able to see my client's detailed flight compensation letter before claim, the LBC, dated the 24th of July 2019, that was sent directly to the respondent. in this letter before claim, it's set out, my clients provided the respondent with the...
Wait a minute, you say it was sent directly. I don't think that's the... The word directly is an unfortunate word, but whatever else it means, I don't think this was sent directly by your clients, was it? It was sent by solicitors on their behalf.
It was, but they're, I think, under paragraph 72 of the judgment of Lord Justice Lewison, they are, or is it paragraph 71 rather? Okay, there's nothing to prevent the passenger from instructing bot or indeed an earlier point. And I think there's the notion that actually, even with the online form, you can instruct a third party. They're simply saying that the respondent was provided with all the information in terms of the flight number, the date.
Wait a minute. My lord suggested you ought to go to clause 19.6 before we embark down this route. I thought 19.6 sub 2 makes it clear that EasyJet will not process claims submitted by a third party if the passenger concerned has not submitted the claim directly to us and allowed time to respond in accordance with section 19.6.1 above. So, I mean, are you saying, well, I mean, I think we ought to look at 19.6 because are you saying that this letter was one that had to be processed by EasyJet? I mean, I well understand, so I should say I well understand why the question and the answer might be different at a later stage when we get to what was done through the portal. But at the moment, I'm struggling to understand why this letter sent on the 24th of July 2019, shortly after EasyJet introduced these new terms and conditions, which may explain why it was done in this way. But I'm struggling at the moment to understand why this letter complies with clause 19.6.2. Or, sorry, complies with 19.6.1, I should say. If by directly it means the passengers must themselves... The word directly is arguably not very precise. It's not clear what it means. I mean, in a sense, it's always sent directly to EasyJet, because you don't send it to somebody else on behalf of EasyJet. But I think it's suggested that what it means is it must be the passengers themselves, because if you look at 19.6.3, it says 19.6.1 and 19.6.2 will not apply to passengers who do not have the capacity to submit claims themselves. So I think what is suggested, badly worded though it is that 19.6.1 requires the passengers themselves, unless they don't have capacity, to send a claim to EasyJet, not solicitors on their behalf.
I may just take instructions.
Yep.
My lord, I simply say, having taken instructions, that it was established in Bot & Co that solicitors or third-party handlers could submit a claim on a party's behalf. I am aware of the wording of EasyJet's term set out in clause 19.6.1, but I would simply say that in Bot & Co it was set out that a solicitor or third-party handler could be instructed.
But that's only after use of the online form, right? That was the bit in, that was paragraph 71, was it? I mean, I thought the whole point about BOT was that Lord Justice Lewison was saying it is legitimate in the first instance to require contractually a passenger to submit in the first instance a direct claim, whatever that means, i.e. not using somebody else. You can use somebody else, like a claims handling or firm solicitors or something, but only after you've, in the first instance, put your complaint in through the prescribed mechanism.
Well, and you can also, I think, use someone else to fill in the form for you. That's what Bob says.
Yeah, but what you can't do is have somebody else actually write a letter on your behalf, apparently. In other words, you can have somebody enter all the information.
Can we put it this way, that there are perhaps two questions. The first is, do you accept that it is a condition precedent to recovery that a claim must be made using the online procedure, to which it seems to me Bot gives the answer, yes, it is. Second, if that is so, is a claim made for the purpose of of clause 19.6 if, using the online procedure, all the details are provided to enable the passenger to be identified, but the booking reference is wrong? And you then ask the question, well, has the passenger made a claim? And it's either yes or no. Is that a correct analysis of what the issues are? And if not, why not?
My lord, if I could just check, your first question was, do you accept that clause 19.6 is essentially a condition precedent to the recovery?
Yes.
Claim must be made prior to the online procedure. And the second question is that if a claim was made for the purpose of 19.6, if all the details input were correct bar one.
Well, except for the booking reference. I mean, if you got the name wrong, that might give a different question, I suppose. But you put in enough information to enable the passenger and the flight to be identified, but you get the booking reference wrong.
So then is it still a claim?
Is that a claim or not? And if it's not, what is it?
So I do come on to this in my submissions, but essentially what I submit, if I may, essentially, I'm just
I suppose there could be a third issue, which is if clause 19 means that even a minor error disqualifies you from recovery, is that a material obstacle?
So in relation to your first question, I would accept that it's a condition precedent to recovery. But then if a claim is made for the purpose of 19.6 and everything but one detail is put in incorrectly, does that mean that you've got enough information to enable the passenger to still have a claim? So I would effectively say that, like in correspondence or this form, it's effectively like a letter before claim, almost. And then I think your last question is that...
So sorry, Mr. Conway, I just want to be... I didn't hear an answer. As I understand it, what you're saying is, to my lord's question, if one detail is wrong, let's say, the answer is yes, that is a valid claim.
Yes, I would still submit
A sufficient claim.
Sorry, it's a what claim?
A sufficient claim to satisfy the test.
Yes.
Yes.
And then as for the last question, if clause 19.6 would... And then if clause 19.6 requires everything to be correct and one thing isn't, does that disqualify this from being a claim?
No. Does that place a material obstacle?
Sorry. Yes, it would place a material obstacle.
In the terminology of the regulation.
I would submit it would place a material obstacle.
Provided that what was provided was sufficient to enable the airline to identify the claimant. I mean, if to take my lord's example, if everything was correct but one digit was wrong on the booking reference, such that the airline could check the name against the flight, it knows exactly whose the claim is being made on behalf of. The fact you filled in the booking reference, if that's an essential, if that's on the form, one digit wrong, shouldn't make a difference. That would be a material obstacle in circumstances where the airline would know that a claim was being made on behalf of correctly named people who would appear on the flight. Flip it the other way round. If the airline could identify the people who were on the flight because their names were given, even if potentially misspelled, but because I know there's an issue about this, I'll get her name right.
Miss Dore, I think.
Miss, yes,
Dore, I think.
Pistida, the A was missed off. But if the airline can identify the people on whose behalf who are making their claim through, say, a correct booking reference, even though the name has been misspelled, then I think the third question is, would not treating that as a claim contravene Article 15, which I don't think you've shown us, but which is referred to by Lord Justice Lewison, saying that you can't put material obstacles in the way of a compensation claim.
Yes, I think I would submit that that's correct.
But none of that relates, just so to back where I perhaps dived in, those questions, which I think the Lord's indicated seem to be the relevant questions, none of those are really assisted by looking at the letter of the 24th of July 2019, because the 24th of July 2019, unless you can deal with clause 19.6.2, it doesn't seem, at least on its face, to be a claim submitted directly by the passengers to EasyJet. It seems to be a claim submitted by somebody on their behalf in circumstances where they plainly have the capacity. Nobody suggested they don't have the capacity to submit the claims themselves. So why does looking at the letter of the 24th of July 2019 help this case in any way?
So, my Lord, if I may, actually, part of that does relate to my submissions that I'll come on to in relation to the application to adduce fresh evidence and the details that are included in this letter of April 2021. That's partly why I was introducing it now, but I'm happy to move past this point.
Well, is it going to help you either way? Because you don't need it if you're right on the submissions you've just made in answer to my questions 1, 2, and 3, and if you're wrong on those, then it won't help you.
No, I think I'll move past it, if I may, my Lord.
Yeah.
My Lords, if I could take you to the acknowledgement email of the 11th of April 2021 then. That's in the supplementary bundle, tab 1. Sorry, if you don't have the tabs, page 14. So in this email, as your Lordships will be able to see, the respondent thanked my clients for their submission of the EC 261 claim, and there was a reference ID in the top, 171816452. Now, in this email, the respondent actually stated that it's been unable to find my client's booking with the information provided. At no point did it say that the information was incorrect or insufficient or anything like that. However, in submissions in the lower court, I would like to point out that actually the submissions were made on behalf of the respondent, but the email effectively said you haven't provided the correct information for us to reference that flight. And I submit that that submission made in the lower courts was inaccurate. And this same submission was made to Her Honour Judge Clarke. And it's repeated again in the sentiment of something being wrong in paragraph 17 of the respondent's, what I'm going to call the original skeleton from August 2022. And that can be found in the core bundle at page 211.
So what inference do you say we should draw from this email about what happened?
So,
well, you're right. I understand the point you're making is that it doesn't have the words it doesn't say the words you've entered wrong information. It doesn't say those
And that's
But
simply,
isn't it a natural inference that this email arises because that's what's happened?
so I would say not necessarily. Actually, it could well have been, and it's equally possible that the form was filled incorrectly, but there may have been, for example, some technical glitch on the respondent system that operated to prevent it from finding the correct booking. And I submit that the judges in the lower courts have, in my submission, wrongly taken it as a fact that the form was insufficient, incorrect, or deficient due to some purported human error when there's simply no evidence of that. So that's the inference I would ask your lordship to draw from that. That it's equally possible that there could have been a technical issue on the respondent side that prevented it from being able to find the booking.
And the simplest thing to have done would have been simply to resubmit the claim as they, and if they'd done that, you'd have been paid years ago.
I recognise that, but the actual email itself doesn't actually say the information we submitted was, as I said, insufficient, incorrect, or anything like that. There could, as I said, there could have been a technical glitch in the system, and so I submit it's not, and as was said to, I think, Deputy District Judge Abrahams, it's not reasonable for the respondent to expect my clients to re-enter, potentially repeatedly re-enter information into the form, and especially when they'd already especially when there had already been a letter before claim that was sent to the respondents. And so this re-entering of information when you don't know what's wrong could potentially go on ad infinitum, and then particularly if it's not stated what the actual error, if there was any error, what it was.
Well, I mean, something clearly has not connected with the system, or the system is clearly not processing things properly. I understand why you say that it's not a very informative response at page 14. Doesn't actually say what's wrong.
No.
It would have perhaps been better if the system does identify which parameter was able to say which parameter didn't compute or whatever. Although, why isn't it a fair inference in the letter that you were going to take, or you did take us to, of the 24th of July 2019, that, and indeed there's some other evidence in that suggests that the person completing the form just doesn't understand the difference between a booking reference and a flight number.
So my lord, what I would say is that's entirely a fair inference to draw, but then there's the equally possible inference that there was an issue on the part of EasyJet systems, is simply that there are these, and so what I'd say in relation to the point about why didn't my clients resubmit the details? You know, how long could they potentially have to go and keep resubmitting this form? Could it be ad infinitum if it's not stated what the actual error was? And there's no, and as I've set out in my skeleton argument, at no point did my clients have the option to save, download, email themselves, or save, download, or email, or forward themselves a copy of the form. And so what I submit, my lords, is that this could have all been put to bed by the respondent simply disclosing a copy of the form and showing what the actual error, was, if there were any error. And what I'd say is the fact is, I do recognise my clients could have resubmitted the details. They've been requested, but we're not. I'd submit we're not dealing with a hypothetical scenario. Rather, we're dealing with the legal consequences of what has happened. And what we know now, which we didn't I wasn't in the trial, but in the trial before Deputy District Judge Abrahams and in the first appeal before Her Honour Judge Clarke, is that respondent does have access to the form. This is information that's only come to light in the skeleton argument since then. And so it wasn't before the judges in the lower courts who, in making their decisions, only had the acknowledgement email before them. And they took the view that as the form they viewed had been filled in incorrectly and or was insufficient, and that as my clients had not been able to produce a copy of such, my clients were in effect barred from bringing their claim in the civil court. But I submit that this finding particularly that the form contained insufficient information to be a proper claim or was deficient, is wrong.
Well, it seems to me those points really go to arguments about the costs of the proceedings, which by now dwarf the original claim, and they have the valid point, or at least a point which may have some force. If you've resubmitted the form and got the details right, none of this would have arisen. To which you riposte, well, if you told us what was wrong with what we'd done first time around, or enabled us to save it, then we could have checked it for ourselves and resubmitted it. But I mean, that's none of that bears on the question, does it? Whether a claim had been submitted for the purpose of clause 19 by the submission of something which had the wrong booking reference.
So I would submit this evidence that the claimant said that there has been reportedly been the wrong booking reference entered, as I said, was only introduced in the skeleton of the 16th of August 2022. There was no application to adduce this evidence or anything. We don't actually know if we've never seen a copy of the data set that was input in the form, so we can't really know how true it is, its credibility or anything like that. So I would submit that while I know it's stated in the skeleton argument that the booking reference was incorrect, simply the basis for that statement, it's not clear because we don't have a copy of the form or the data set.
Right. So do you say that's a factual inference we should not draw?
But the factual inference that we should draw is that the information was insufficient or incorrect. I submit that it's something that it shouldn't be drawn without evidence, I submit.
Well, what about the evidence at page 169 of the bundle, which is the email sent from your instructing solicitors to, by Lovett's anyway, to EasyJet. A couple of weeks later, it says refer to your recent response. I'm not sure what the response is, unless that is, in fact, the email we've just been looking at. Saying, because we've been advised by a client that contact has been submitted direct to you. It references the same reference ID that appears on the email. But yet again, the booking reference is erroneously given as the flight number. Why isn't it a pretty good inference that whoever's been filling in the form online has made the same mistake?
My Lord, if I may, if I could take you to the order of Deputy District Judge Abrahams, which can be found...
Well, you can, but only if that's going to answer my Lord's question.
It will, but briefly in relation to the flight number on page 113, it says, and upon flight U22857 from Milan to Alghero on flight on the 1st of June 2019. So this was the order that was put before, this was the order that was made by Deputy District Judge Abrahams on the basis of the information. And Mr. Taylor was present in that trial, and so simply saying that actually that flight number is the one that's been...
Yeah, no, sorry, you're missing the point. At the head of page 169, I don't really care whether the flight number is correct or not, because the airline will recognise the U2 prefix that's used within the industry, as opposed to the EJU, which is, as I understand it, a customer-facing reference. It's the reference, the booking reference. The booking reference is plainly the flight number. It's just wrong.
So I submit that what you're saying is correct, but I think just saying that drawing the inference that the form itself was insufficient or incorrect, and we don't have a copy of it, is one that can't be made because there's no evidence in support of that. That's what my point is. But I do accept that the correspondence from the solicitors instructed by my client does have the wrong booking reference and flight number. I do accept that.
Well, so the flight number, I suspect, would not have would not have caused any problem at EasyJet's end, but because certainly but that's just a surmise on my part, because the actual 2857 is correct. It's the booking reference that's the problem. The inference being that, which continues, incidentally, in the witness statement in support of the application to adduce new evidence, the same mistake is made. But anyway, you say that the judge isn't entitled to draw the inference that there was some error in the information inputted.
They-
that has caused this response on page 14.
Yes, the judge was entitled to draw that inference, but all I'm saying is based on the wording of the acknowledgement email, it was equally possible that there could have been a technical issue on the end of EasyJet, and that without a copy of the form, we can't know if the form itself was actually incorrect or insufficient. But it's an inference that the judge could have drawn.
Okay, well, where do we go from here?
So as I've said, what I've said is that there's nothing in the case law suggests that filling in the form incorrectly operates as a complete defence or a bar to bringing proceedings. Rather, I think, as is set out in paragraph 70 of Lord Justice Lewison's judgment, the form seems to be a way to first channel the prospective action. So I submit that it seems to be closer or more akin to a letter before claim than anything else. So I submit that it would be entirely contrary to the overriding objective, and that would be unfair and disproportionate to bar my clients from issuing proceedings in the courts based on a purportedly incorrectly filled in form or insufficient form, when the introduction of the form was likely part of an understandable policy that seeks to channel a complaint, at least in the first instance, through a process backed by the national regulator. No argument that it makes sense to have that sort of policy.
Right.
But essentially, having filled in the form and submitted it, and then there being no evidence that there was actually anything wrong with it, and then waiting the requisite time, I submit that my clients had the right to seek redress through the courts, and which they did, and they issued their claim on the 8th of June 2021, and there was nothing that operated to bar them from doing so. And that if we're taking the position that if there's any error whatsoever in the form, then I submit that that would be a material obstacle or impediment to consumers obtaining compensation to which they're entitled. So I suppose the question is then what would amount to an appropriate sanction, I guess, if the form had been filled in incorrectly or insufficiently, and I submit that an appropriate sanction for this, with a letter before claim, would be potentially costs. And the basis for this submission that costs may be an appropriate sanction is that, pursuant to the procedure rules, on any track, all parties are encouraged to engage in various steps before commencing proceedings. So if a party has not complied with the relevant pre-action protocol, or there's been some error, the court can and has discretion to take that non-compliance into account when determining costs. So I recognise that we're talking about a matter on the small claims track, but even on this track, you can have costs imposed if the court considers there to have been unreasonable behaviour. And I submit that perhaps a failure to potentially, and this is hypothetically, if there are one digit misspelt on a booking reference, that's not unreasonable behaviour. So on this first issue, I submit that the purported failure to correctly fill in and submit the form on the respondent's web portal does not act as a complete defence or something that bars my clients from bringing proceedings to claim for compensation. Rather, as I've said, the form is a way to first channel the prospective action, and it's more akin to a letter before claim. And if a letter before claim has got some, maybe one incorrect detail, that doesn't prevent a party from issuing proceedings. And so,
if there is an error
yes.
on the submission of the online form,
Mm-hmm.
do you say that that can be corrected by another route subsequently? And the reason I ask you the question, just so you see it, is that going back to page 169 of the bundle, albeit that the booking reference is still incorrect, what that email has done is to reference the online submission and provided the name of one of your clients, not two, but one of your clients, and at least in relation to that client, and I think we'll find out, in fact, it's both clients, would have did in fact enable EasyJet to identify exactly who it is making the compensation claim, even if the online form had been filled in incorrectly. And do you say that it's possible, having failed to complete it correctly, is it possible then to correct the mistake subsequently? Or does 19.6, is it the only, is correct completion of the portal the only way through 19.6?
So in coming to the first point, if you were, in terms of correcting it subsequently, if the acknowledgement email had set out what was wrong or attached a copy of the form, then had it gotten to the point of issuing proceedings, all of the details. Sorry, let me restart. So. So, in terms of correcting it subsequently, I would say that if the email had either said the error or that the form had been attached and just said this is the error, then it could have been corrected subsequently. And then, my lord, if I could ask you to repeat your second question.
Well, I can't remember what the second question now was, but it's basically whether you can correct an error in the input on the portal, which has caused this email to come back. Can you correct it using something other than re-input on the portal and comply with clause 19.6 as a matter of looking at clause 19.6?
When I took the judge through how the electronic submission of the form worked, once you submitted it, we didn't explore further if there was a way to amend it. It just simply came up with the acknowledgement email, and that was it. But I would say, no, we're not aware of anything on the portal that would allow you to amend it at a later date. And so, looking at clause 19.
Well, presumably that's why they wanted you to resubmit the whole thing.
Yes, and
in effect, to start again. And I wonder whether a correction outside the online process would be sufficient or relevant, because either what you have submitted with the booking reference error is a claim, in which case you don't need to correct it in order to be allowed to pursue proceedings, or it's not, but you've accepted that the making of a claim is a condition precedent. So anyway, we probably don't need to decide that, because you didn't try and correct it in the way that we're now exploring.
Okay, I think my question was whether you... I think it's apparent you didn't, or there's no evidence of an attempt to correct using the online form, i.e. to resubmit the details online. There's no evidence of that, as I understand it. What there is evidence of is a submission or an email sent to EasyJet, which is at page 169. In other words, which references back to the attempt to use the portal. I won't use the word claim because that's tendentious, but it's a reference back to the attempt to use the online portal because it contains the correct reference ID that the portal generated. But it does supply information from which my understanding is that EasyJet was then able to identify on whose behalf the claim had been made, because my understanding is you were going to seek to adduce the letter of the 26th of April, 2 days later, where EasyJet know exactly who the claimants were. They have identified correctly the booking references. They know everything, but say, we reject your claim because you didn't comply with clause 19.6. And what I was asking is whether you say it is compliant with 19.6 to have submitted a claim containing an error, assumed for present purposes,
Yeah.
if you subsequently correct it through another route.
I would submit that that is correct. I think if there has been an error, and you're informed that there has been an error, there's been some sort of attempt to remedy that error or correct it, then I think that has to be, yes.
Oh, that was my right. Okay.
So,
We'll see what Mr. Temmick says about that in due course, but right.
so if your lordships aren't with me on this point and take the view that the failure to correctly fill in the form does act as a bar or complete defence, I will then move on to my second issue, if I may. And the second issue is essentially how to deal with the evidential gap and absence of disclosure obligations on the small claims track when one party does not have the one piece of paper or documentary evidence it requires to prove its claim, while the other party definitely does have it, with such having been evidenced by the opposing counsel's both of their skeletons, but that party has failed to disclose or otherwise provide it. So if that other party, in this case the respondent, has chosen to not disclose or otherwise provide this one piece of paper or documentary evidence, does this mean that my clients cannot obtain redress? So I submit that that simply cannot be right or just, and that's an important point of principle of evidence that warrants consideration by your lordships. And so the one piece of documentary evidence that my client needed to prove its claim was the form. And as I've set out in my skeleton, at no point was there any option for my clients to save, download, forward, or email a copy of the form to themselves. If you need the paragraph in my skeleton, it's 58. Further, they were never sent a copy of the form by the respondent. They only received the email of the 11th of April 2021, but there was no attachment of the form to that email. My clients have never and still do not have a copy of the form. By contrast, we do know that the form was received by the respondent. That's clear from the acknowledgement email. And what the judges in the lower courts, like my clients, did not know was whether the respondent had a copy of the form. And this is actually reflected in the order made by Right Honourable Lord Justice Nugie on the 12th of July 2022, which your lordships can find at page 184 of the core bundle. It's tab 13, you do have tabs. So in giving permission to appeal, Lord Justice Nugie said, and I quote, "I accept that there is an important point of principle involved, namely whether the lower courts were right to hold that it was incumbent on the claimants to establish what were the contents of the form that had been submitted when they had no copy of it and the defendant presumably did. I also accept this ground has a reasonable prospect of success. However, what we now know for certain, and we know that from the respondent's original skeleton argument, specifically paragraphs 33 and 34, is that the respondent can access and it has stored somewhere a copy of the form. Whether the contents that have purportedly been extrapolated from it and relied upon in these paragraphs, I submit is irrelevant in relation to this issue, but I'll come on to that later. But irrespective, we know that the respondent both received and can access a copy of the form, but it's failed to disclose or otherwise provide a copy of it to my clients and to the courts.
My lords, we're proceeding under a misapprehension about the word form and the way my learned friend has used it, which I've criticised in my skeleton argument. There is no form.
Yes, but,
There's no piece of paper.
but you do have access to the data which
Correct.
was submitted. We understand that.
Very good.
I'm happy to use the word dataset if you would prefer my not.
Mm-hmm.
So,
I mean, what appears on the customer's screen may look like a form, but by the time it arrives in the airline's computer, it's simply data.
I entirely accept that. I was just using the word.
No, all right. Anyway, we've cleared that up.
So now on either the fast track or the multi-track, my clients would have been able to obtain a copy of the form through the disclosure process. And while there is the pre-action protocol that expects parties to disclose key documents relevant to the issues in dispute, there is no disclosure process or set of obligations on the small claims track. So the question is how to deal with the situation, as I've said, when my clients do not have the one piece of paper, or the one set of data rather, that they require to prove their claim, while the respondent is in control of this data set, has access to it, but refuses to provide it. Does that mean my clients cannot obtain redress? And as I've said, I submit that that simply cannot be right or just.
Did you ask them for it before the trial in the small claims track?
I just- That information was not requested.
Because you said refuses, and as I understand it,
Oh, sorry.
since you just explained that you didn't ask them, it's not actually accurate to say that they refused.
If I can say
prior to
that has
trial.
withheld it, then has withheld.
Sorry?
If I may use the term withheld.
Well, it's up to you what you say, Scott. But you did say refuses, and that's why I asked the question.
I understand. I would say then withheld. So as I've set out in my skeleton at paragraph 60, while the small claims track is not subject to the disclosure regime, modern trial procedure places emphasis on the pre-trial disclosure of evidence. In support of this, I've cited paragraph 10-8 of Phipson on evidence, the 20th edition, 31st December 2021, Sweet and Maxwell, which I'm going to call Phipson going forward. And this paragraph, which your lordships can find either in my skeleton or in the authorities bundle at page 24, Page 24 provides the policy of litigation conducted at trial through a cards-on-the-table approach has continued throughout the CPR. So what I would say is initially the case that respondent pleaded was the submission of the form did not occur. At the trial in the first appeal hearing, in what's arguably a different argument, the respondent argued that the form was either filled in incorrectly or was insufficient to properly found the claim.
I suppose another way in which this point might be put, bearing in mind that there is no disclosure obligation on the small claims track, is that a system which does not enable the customer to save a copy of the details submitted may constitute a material obstacle if that means that the customer is unable to show compliance with clause 19.
I agree with that. I submit that's entirely fair.
I mean, the circuit judge answered that by saying you can take screenshots.
And I will come on to the screenshots point slightly later if I may, but I promise it won't be too long. And so if I may continue just with the submissions, and then I'll deal with the screenshots point, and I think she also said you could print the form on your computer, I think as well, is what she said. So if I come on to that in a little bit. So in paragraph 6-2 of Phipson, which I've set out, paragraph 56 of my skeleton, or if you're in the authorities bundle at pages 18 to 19,
So what paragraph of Phipson is it?
so 602.
602. Yes, I've got
18 at the very bottom, so the paragraph at the bottom, and it says the evidential burden, and then is sometimes referred to as the duty of passing the judge or the burden of adducing evidence. It obliges the party on whom the burden rests, if you turn over the page, to adduce sufficient evidence for the issue to go before the tribunal of fact. If I could then take your lordships down to paragraph 604, which is on the same page, page 19. And the first line of that paragraph says the general rule is that the party who asserts must prove. And then I could ask your lordships to turn over the page to page 20, please, to paragraph 606. And so, it says, where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegations rests on that party. If, when all the evidence is adduced by all parties, the party who has this burden has not discharged it, the decision must be against him. This is an ancient rule founded on considerations of good sense and should not be departed from without strong reasons. Now, in paragraph 606, there's, I think it's about the second line, there's footnote 14, and that's a reference to the case of Emmanuel against Avison 2020, England Wales High Court, 1696 Chancery Division. My lord, so in paragraph 48 of your lordship's judgment in this case, when you were sitting as Mr. Justice Birss, you cited the statement of Lord Justice Bowen in the case of Abraith against North Eastern Railway, 1883, 11 Queen's Bench Division, 440. And if I could ask your lordships to turn to page 28 of the bundle. So you cited that wherever a person asserts affirmatively as part of his case that a certain state of fact is present or absent, or that a particular thing is insufficient for a particular purpose, that is an averment which he is bound to prove positively. Now, pursuant to the case I've just mentioned, I submit that the respondent was bound to positively prove that the form was either incorrect or insufficient, having raised this argument at trial, although it wasn't pleaded in the defence. The respondent, as the party that received the form and is in control of it, has withheld or failed to otherwise provide primary evidence, i.e. a copy of the form to support its assertions. And actually, under CPR Rule 27.4 bracket 3, the respondent should have served a copy of the form, I submit, on my client and the court at least 14 days before the final hearing, as it intended to rely on it at the trial.
I mean, just so I understand, all this arises, is this right, on the assumption that we can reach no conclusion about what, if anything, went wrong. So we can't conclude that you submitted the form correctly, and we can't conclude that you made a mistake because of the booking reference. We simply don't know what happened. All we know is that something, a button was pressed to submit something, and that a rejection came back. Is that the factual basis for these submissions?
So just in terms of the rejection, it was saying that we've been not so much a rejection on the basis of anything being necessarily wrong, just being unable to locate.
Yeah. So all we know is you submitted something, we don't know what, and you got the email back.
Yes. Yeah. That's all we actually know.
Yeah. Okay. That's the factual basis for this argument about the burden of proof and so on.
Yes. So accordingly, I submit that the respondent has never positively proved its submissions. Rather, it's that the burden of proving the contents of the form rests on my clients. And I submit that this cannot be correct, and that the finding of Her Honour Judge Clarke, as set out in ground 6 of the appeal, therefore has to be wrong and/or unjust. We now know for a fact that a copy of the form is readily available to the respondent. And it's on this basis, along with the fact that the respondent has not come to the standard of proof, that I submit adverse inferences can and should be drawn. If I could take your lordships to the authorities bundle, tab 5, at pages 33 to 34. It's paragraph 45-34.
So just give me the page reference again.
33 in the authorities bundle.
Thank you.
And that should be paragraph 45-34 at the bottom of the page. And so that paragraph provides a court should try a case and decide on the basis of evidence before it. And then the last sentence in that paragraph says, it's of course open to the court to find a case or allegation of fact to be proved if a party does not call any evidence to rebut it. Inferences can be drawn from a defendant's failure to give evidence. And then goes on to say, in civil cases, the court can in certain circumstances draw an inference against a party who fails to produce evidence which ought to have been available to him, but he has chosen not to call or produce. If I could then ask your lordships to turn over the page to paragraph 45-36 that fits in. It goes on to state, in civil cases, the process of disclosure documents is an important one in ensuring cards on the table in the endeavour to establish the truth. In certain circumstances, an adverse inference may be drawn from the failure of a party to produce documents. The court should only draw an adverse inference if it's satisfied that the party had the documents in the first place and was responsible for the absence. There are two inferences that may be drawn. First, the court may draw an adverse inference as to the credibility of the party who has withheld the documents. Thus, the inference may be drawn that the deliberate withholding demonstrates a consciousness of the weakness of the party's cause in general, and from that consciousness may be inferred the fact itself of the cause's lack of truth and merit. The second main inference is that the specific document is unfavourable to the cause of the party who has withheld it. For such an inference, there should usually at least be some evidence of its contents, and the inference should only be in relation to the specific fact or issue to which it relates. So as I've said, my clients cannot and have never been in a position where they could produce a copy of the form. And and so they've never been able to provide it to the court. And however, we now know that the lower, and are certain, which the lower courts did not, that a copy of the form is available to the respondent.
Can I just, because I've just lost the thread a little, can I just go back?
Yes.
If you go into the, I just want to look at the particulars of claim and the defence to see how this arises. And you'll forgive me for perhaps, I hope, for a little bit of lack of knowledge of the small claims process. But the particulars of claim at page 114 makes no reference at all to anything to do with the claim. It simply recites the flight. Still gives the wrong booking reference number, as a matter of fact, and claims compensation. To which, at page 119, EasyJet, at paragraph 6.6, or what is said to be the defence, I think, but obviously goes, it's an argument document, in fact, as you'll see. But at 6.6, EasyJet says EasyJet denies, and then just for good measure says, and it's not alleged, i.e. by you, that the claimants have at any stage submitted a claim for compensation. Now, on the face of those pleadings, what's the actual issue that is to which any disclosure of documents would go? You don't go back in a points of reply and say, oh yes, we did. We did, but we haven't got a copy of it or anything like it, as I understand it. There's just a silence. Is there a general assumed joinder or what? I mean, you keep on saying, somebody has withheld the documents, or some inference is drawn, and you keep on talking about the process of disclosure of documents is an important cards on the table principle. But I thought disclosure, certainly in the multi-track, is based upon issues as defined by the pleadings. Where's the issue to which disclosure of the form submitted by your clients, where's it identified?
My lord, it's not in the pleadings, but in the witness statement of Miss Hamblin, which is the 11th of November 2021, in the supplementary bundle, we've got her saying, upon the defendant's response to the letter...
Sorry, hang on.
Which paragraph?
Sorry, the supplementary bundle, page 2, paragraph 9. So it's correct that there was no sort of reply to defence or anything, that's correct. But in the supplementary bundle, page 2, paragraph 9.
And so this is what? This is
was
for trial, isn't it?
Yes, that was a witness statement that was before the Deputy District Judge Abrahams in the lower court. And in paragraph 9, she sets out that upon the defendant's response to the letter before action, advising that the claimant's booking was made under the defendant's new terms and conditions, the claimant did make a direct submission using the defendant's web portal, which was logged under reference ID number. The claimant received an email from the defendant stating that the details could not be located. We've then got the next paragraph talks about the submission. And then following that, in terms of the documents that we provide, my clients provided the particulars of claim, claim form itself, the letter of the 24th of July 2019, the boarding passes and the acknowledgement email, and a blank copy of the compensation form is what we've got. But and then in response, what we've got, for the respondent for the trial, we had the witness statement, I think, of Miss Victoria White, which
This is dated earlier, isn't it?
the 2nd of November 2021. Yes.
Whereas Hamblin's the 11th of November.
Yes.
So did they cross or what?
Just taking straight. taken instructions. We don't know if they crossed. It would be that they would have been submitted prior to any deadline set by the court.
It's sort of unlikely, because if you look at paragraph 13 of Miss White's witness statement, page 54 of the bundle, it asserts again, prior to proceedings being issued, the claimants have made no direct contact with EasyJet. I mean, it looks as if that was made before sight of paragraph 9 of Miss Hampton's witness statement, or at least there's no comeback. So I mean, it probably suggests that they, in a sense, did cross, or at least they were produced on the dates that they bear.
My lord, I can actually help. This was presented on the date, or served on the date stated on the statement, because the writer of the statement was about to go on leave. So this was produced first and was submitted. And these statements were the statements and evidence relied upon by the parties at the first trial.
So they sort of do supplement. Thank you. I mean, they sort of supplement the pleadings, do they? In some.
Well, it's the trial evidence, and indeed disclosure as I mean, whether one can criticise the content, but that was the purpose of the statements. I'll come on to that in my submission.
So Ms. Cochrane, you say that the issue of whether there was a portal submission, or at least what was wrong with it, was live before the district judge. I think that's what you'll say, even though it wasn't on the pleadings, the issue was full. It was there in front of the district judge.
It was alive before the district judge. And then that's why we've also got the submissions by, I think it was Mr. Taylor, when he's saying that there was insufficient or incorrect information
Right.
in the form.
But as my lord asked you earlier, you didn't say, well, give us a printout of the data on your computer.
No.
Right, where now?
So as I've said, my clients have never been in a position where they could produce a copy of the form. We know that a copy of it is readily available to the respondent, and I note that, I submit that the respondent has provided no coherent explanation for not providing it, having relied on it in its submissions at the trial. So in paragraph 41 of its original skeleton, of the respondent's original skeleton, which your lordships can find at page 217 of its core bundle.
What is it, 217?
Yes.
I don't have 217 of the core.
No. 217 of my core bundle is a bit of the respondent's appeal skeleton that was replaced.
Sorry, that's what I'm calling the original skeleton, because it was the skeleton of the 16th of August rather than the new skeleton that came in last week. That's why I was calling it the original skeleton.
I see.
I'm sorry. I'm sorry. I don't.
I think that's the terminology you gave us at the outset.
It was, but it's all my fault.
My fault. I misunderstood you. I thought you meant a skeleton that was before
No,
district judge.
you don't have. I can pass a copy up to you if you.
All right.
Sorry, I had substituted mine. Sorry.
Well, my lords, I think you're about to be shown a copy of my predecessor's skeleton argument, and I don't rely on that skeleton argument in any way. One of the reasons I don't rely on it is because, in my view, improperly, it put forward evidence in the skeleton, which was not before the district judge, nor the circuit judge, nor the subject of any application before this court. And so, for all those reasons, for those and many other reasons, I decided that I would prefer to rely on my own skeleton argument, which didn't include evidence.
Well, if it contains admissions, I suppose Ms. Cochrane is entitled to rely on it for that purpose.
Well, if she would like to cast that assertion in the skeleton argument as an admission, I'd be interested to hear how she does that.
I have to tell you, Mr. Temming, I had read that skeleton before you sent in your skeleton.
Well, I'm not
I'd
saying you
already
should.
had the benefit of seeing them putting in the material which comes off the EasyJet database.
Well, I'm not inviting you, Lord, to unread it or even put it out of your mind. I'm not relying on it. As I say, I thought it was inappropriate to put that in the skeleton argument, and that's why I've excised it from mine.
if we're going to look at it, I'm afraid I had substituted it in my bundle and left it, I think, somewhere. So if you do have a copy, I'd be grateful.
My lord, in paragraph 41 of that skeleton, it's at page 217. As a quotation, that there's an inherent tension between the competing requirements of accuracy, cost, and time in determining disputes, and that's accepted. But the fact is here, I submit, we're looking at a form that we know that the respondent has access to. If I could ask your lordships to turn over the page to paragraph 43, in the last line of that paragraph, as well as in paragraph 46 of this original skeleton, which is on the same page, the respondent states that what's required is to get a technician to extract data from a server and reproduce a web form and print the data set. Yet in paragraph 46 of this skeleton, it stated there would be too onerous a task and too granular for a small claims hearing. In my submission, it would have taken very little cost or time, particularly in comparison to a trial and 2 appeal hearings, to provide a copy of all the data on the form.
How are you making submissions about cost and time?
Sorry?
How are you making submissions about the cost and time?
I've just been asked how I'm making submissions about the cost and time. And simply, I would say that there's no evidence that there would be too onerous a task, or as to how long this sort of task would take, or the sort of steps that would be taken to provide a copy of all the data on the form. And potentially even have a witness statement from the person who undertook this process and explain the steps taken to do so. But this hasn't been done. Rather, I submit that the respondent has simply chosen, despite having relied on it in its submissions, has chosen not to produce a copy of the form. And given the passage I've just quoted concerning inferences, the inference I submit that may be drawn from the respondent's decision to withhold the document is that the case either lacks truth and merit, or that the form itself is unfavourable to them. I submit that your lordships cannot know which inference is correct until the form is disclosed or otherwise produced. So if we look at what my clients could do, my clients have never had a copy of the form, and therefore they could never provide it to the court. However, as I've already shown you with the exhibit of mishandling, my clients tendered secondary evidence to the lower court in the form of their letter before claim, boarding passes, a blank version of the form, and the acknowledgement email concerning submission that was automatically generated by the respondent. Did you need those documents? That's all in this supplementary bundle.
Right.
If I could take your lordships to the authorities bundle at tab 6, page 38. It's paragraph 4129 that your lordships should be able to see on that page.
Sorry, what paragraph? 40?
It's paragraph 41-29. It's on page 38 of that bundle.
Yes?
And in that passage, it's provided that the party tendering secondary evidence must prove the existence of the document directly if possible, or presumptively when not. And if I could then ask your lordships to turn to tab 5, so pages 30 to 31 of the authorities bundle. You should be able to see paragraph 45-30. And so at that paragraph 45-30, it says, contemporary documents play an important part in establishing the truth, establishing the facts. And then over the page where it says guessman, if you go to essentially the last bullet point, it says the best approach from a judge is to base factual findings on inferences drawn from documented evidence and known or probable facts. So I would submit through tendering the secondary evidence that my clients have, when the respondent have provided none in reply, I submit that my clients have shown, at least presumptively, the existence of a filled-in form and that it was submitted to a respondent. In relation to the weight that the court should have placed on the secondary evidence, I refer your lordships to paragraph...
But hang on, I mean, nobody doubts that something was filled in and that it was submitted to the respondent, to the airline. Nobody doubts that. That's perfectly plain. The question is, what did it contain? I mean, it's apparent from the email you got back that something had been submitted. I mean, the question is, you know, was what was submitted sufficient to comply with clause 19.6? That was the sole ground of defence. As I read the pleadings, EasyJet said you didn't go through 19.6, therefore we don't have to process your claim or pay you. You said, yes, we did. We put a form in, look at the response we got, and then the question is, was what you put in sufficient to comply with 19.6? You say we couldn't prove it was because we don't have access to the data that would have sat on the computers of EasyJet.
Yes, and
EasyJet say, you never asked us for it. I paraphrase.
Yes, so what I would say, sir, is that essentially that as I've said, the respondent in its submissions in the trial was that the form was insufficient or was incorrect, and arguably that wasn't raised in the defence. And then the judgment comes to the point of saying, well, I think with Deputy District Judge Abrahams, that he says, well, I don't have any evidence of the initial complaint made. And so he dismisses the claim. And so what I would say to that, sir, is that in holding that my clients must provide a copy when they've never had one, the court's imposing an evidential standard on my client that would be impossible for my clients to meet. And that's the important principle of evidence that I submit your lordships need to consider.
But it's all a bit weird, isn't it? I mean, what actually happened is, the particulars of claim never said anything about whether your client had complied with 19.6. The defence denied you'd done anything. The defence witness statement that came first also denied you'd done anything. And then the last document before the trial was your client's solicitor's witness statement, which said, purported to prove you'd done something, but only by producing an email which said that whatever you've done didn't work. So what ended up happening was the judge is sitting there reading, the only proof you've got that you've done anything is an email you got that tells you that it didn't do it. And everything's gone on from there. That's what's happened. We all know what's happened. So why was the judge wrong to say, when faced by your attempt to prove you've done something by an email which proved it didn't work, why was he wrong to say that he wasn't satisfied what you'd done?
Simply, my lord, I would submit that because he's saying, because he had no evidence of the complaint made when my client never had a copy of the form, to dismiss the claim on that basis, I submit has to be unjust or wrong. And I know that and just coming back to my lord's point about the screenshots, Her Honour Judge Clarke did talk about taking screenshots or printing the screen immediately prior to the submission of the form. And to say that my client had to do that in anticipation of civil litigation concerning...
I mean, I fully understand why you would criticise the circuit judge for saying that person submitting the form should take screenshots at each stage, or even of the completed form on their computer, because unless I've missed something somewhere, there's no warning given to the person completing the form while they're doing it. Oh, and by the way, once you've hit submit, you won't be able to see what you've submitted, which is quite unusual. A lot of forms, do allow you to save it or do something else. But be that as it may, the real issue from my perspective is that nobody seems to have actually asked EasyJet to produce anything. You on a month before the hearing, you have an exchange of witness statements where there's a dispute about whether there was a submission. You say there was. They say there wasn't. It's pretty obvious that there might be an argument about the content of the submission given the email you got back. Why should adverse inferences be drawn against EasyJet when nobody's actually asked them to produce anything, and it's apparent that they're not under any positive obligation to do so under the rules?
My Lord, I think that comes back to the point that I was making about EasyJet. While it's accepted that there was no request essentially asking for that form, EasyJet did seek to and did run this argument that the form had been incorrect or insufficient. And as I've said from the authorities that I've quoted, if they're to rely on this, they were sort of bound to positively prove their assertions. And so to positively prove their assertions, they needed to provide a copy of the form.
But it seems very odd to invite the court to draw an adverse inference to the effect that you submitted the claim with all the details filled in correctly when we know that you kept getting the booking reference wrong. So it would be surprising if on that one occasion you got the booking reference right, wouldn't it?
It may be.
I mean, Mr. Temming says there are other errors in the letter before claim, like missing off the A off Ms. Pastida's name and using the U2 flight number rather than the customer-facing one. But whatever the point about those, whatever those points may amount to, we know that you kept getting the booking reference wrong. So to draw, if the inference you're asking us to draw is that you got the booking reference right on the online submission, that seems a bit ambitious to me.
I think
it doesn't detract from the argument. Is that sufficient to satisfy clause 19? It either is or it isn't. But as a factual inference, it seems, as I say, a little bit ambitious.
I understand. If I may continue. So while it's acknowledged that the value of the claim in dispute is very low, it's €500. In terms of public interest, I would submit that the impact of permitting the judgments to stand in the lower courts would be significant, because the decision by a circuit judge, which I submit will attract deference from district judges likely to hear claims of this type, imposes an excessive and practically insurmountable evidential burden on claimants and consumers more generally. To oblige potentially millions of consumers to either take screenshots of their computer or print every form immediately prior to submission in anticipation of civil litigation, I submit is an excessive, onerous and manifestly unreasonable burden, especially when we know that the respondent's copy of the form is stored in its database. So I just say that the reason this finding is the reason that the finding of Her Honour Judge Clarke was problematic in relation to screenshots and printing is, as I've set out in paragraph 78 of my skeleton, there's no provision in the contract between the parties that required my clients to be able to provide a copy of the form in order to issue proceedings in the civil courts. Nowhere equally in that contract does it specify that prospective claimants have to take screenshots or print a copy of the form. So I submit to introduce what would constitute a furtive and unparticularised additional step, maybe beyond the sort of wherewithal of many internet users. And I know my Lord has already mentioned sort of other platforms and providers seem to be able to provide customers a copy of their submissions, while the respondent has, on its own system, has not provided any option to save, download, email or forward a copy of the form. And in terms of examples, I suppose one is if you're submitting an income tax return on gov.uk, at any point you can save your form in order to review its contents and can see it after submission. You get all the details that you've submitted in the form. And another example is that, for example, if you were to purchase a product online, you wouldn't expect to have to take screenshots of what you filled in order to prove that you purchased whatever you did. I submit that your lordships would simply not expect to have to do that, nor would consumers. You would expect that upon submitting the form or purchasing whatever it is that you're purchasing, you would either receive an email with the details you provided in the form or proof of purchase, perhaps in the form of a PDF, or that you'd be given the opportunity to download, save, print, or access at a later date a copy of what you've submitted. The respondent system doesn't do that. And I submit that this is a flaw in their own system. And it's something that actually puts an unjustifiable burden on consumers or prospective claimants. And so while I submit that this position adopted by the respondent in relation to my clients is unreasonable, I submit that it would be even more unreasonable if, for example, the court were to consider blind or visually impaired people who, and I recognise that I haven't put this in my skeleton, but in light of persons who are blind or visually impaired and rely on third-party software to read the text of the web pages to them, in the absence of any such stated requirement about screenshots, or that they need to keep a record of that which they've submitted, how would they know to take a screenshot? How would they know which part of the form to take a screenshot of? And then also for those who are potentially technically less literate, they might not know how to screenshot a page or how to print it. So I submit also in upholding this judgment, the courts could potentially be enabling large companies based on their own potentially deficient indexing or record-keeping practices to keep claims going through this process ad infinitum. Permit companies to contend that they did not receive every single piece of information without providing any evidence of such to that consumer, and use this essentially as, I'm going to call it a get-out-of-jail card from providing compensation. And I submit that this would amount to putting a material obstacle in the way of making a compensation claim. It would significantly impede consumers from obtaining redress to which they're entitled. And so, building on that, in terms of the overriding objective, as well as in relation to the interests of justice and the public, I submit it would be unfair and disproportionate for the judgments of the lower courts to be upheld. And that concludes my submissions on issue 2.
Richard, anything further?
No? Well, thank you very much, Ms. Cochran.
If I may, then it's the application to adduce fresh evidence.
Ah, you're coming
That's
through.
the
I thought
last-
you finished.
Sorry.
All right.
So the last one is I urge your lordships to exercise your discretion to permit the reception of fresh evidence, with such taking the form of the respondent's letter dated the 26th.
Now, what do we get from that evidence, and what issue does it go to?
So it goes actually in relation to issue 1, and
Can we just have it open? Where is
yes,
it?
if your lordship goes to the core bundle, tab 12, that's pages 153
Yep.
to 154.
Yes.
And you've seen from my skeleton that I've outlined the test and everything, so I don't seek to take you through that. But if you go to the very bottom paragraph of that letter, I can take you there.
For the avoidance of doubt?
It says, in the event that you or any
Previous page, yes.
if in the event that you or any nominated law firm proceed to commence court proceedings without first complying with Article 19.6, we will instruct our own lawyers to reply to the court requesting proceedings are immediately stayed. And I submit that the wording of the letter supports the position I've submitted in relation to issue 1. It shows in my submission that the respondent itself does not consider the purported insufficient or incorrect filling in of the form, or even actually if you haven't complied with clause 19.6 at all, to be a complete defence or bar to issuing civil proceedings for compensation. And I've quoted the relevant paragraph. And so it says actually, rather the respondent says it would instruct its lawyers to apply for a stay. However, in this case, EasyJet's lawyers didn't apply for a stay. So I submit that the respondent should not be able to selectively. I'm going to scratch that. And then I've set out the reasons in my skeleton as to the limb 1, limb 2, and limb 3 being satisfied. I recognise that the reasonable diligence and accept that the letter was found after the trial, after the appeal rather. My instructing solicitor, who only has conduct of the matter, did not have conduct throughout. The reason for the letter not being provided is quite simply that it was missed. I submit it would have an important, if not decisive, influence for them too.
Well, that's what I don't really understand, because, I mean, I don't see how it goes to the question whether the online submission constituted a claim, and if it goes to some other issue, I don't know what that is either.
I think it's just saying that it doesn't. That last paragraph simply just shows that, even in my view, that the respondent itself did not view that if you either incorrectly or insufficiently filled in the form, or actually if you failed to comply at all with clause 19.6, that you'd barred from issuing proceedings. I think that's why I've highlighted that in relation to issue 1.
All right. Can you help me with one? I understood you might be relying upon it for a different reason.
There were other reasons to be relying on it.
But
yes.
I took you to page 169, which was the letter of the 24th, the email of the 24th of April 2021,
Yes.
which had the reference of the unsuccessful use of the portal, the ID.
Yes.
And as I understand it, this letter of the 26th of April is a response to that.
Yes, and what I would say, my lord, is that actually it shows that they were able to identify, they being EasyJet, were able to identify the actual information relating to my client's booking in this form, in this letter rather. So I'd say that that's another reason why it's an important letter to have adduced, because having said that
It's curious because I find the letter a curious one, because in the previous letter you gave the reference ID for the direct use of the portal. It's what came back. This response says, having reviewed our records, we cannot trace evidence of any contact made directly to us by your clients to request resolution of their claim, which is odd because you gave them the reference and they have clearly tied up your acting with your two clients because they include the correct references, the booking references at the top under our reference. Those are the two correct booking references. Now, yeah. I don't, having some difficulty understanding whether it is suggested, and it may be that we have to wait to see what Mr. Temmick says about this, but it's difficult for me to understand the statement that they cannot trace evidence of any contact made directly by your clients when they know exactly who your clients are and have been provided with the reference ID for the attempt to use the portal.
I agree, and all the details that they've said that my client needed to input, and actually a lot of these details weren't contained in that letter on page 169. So you have to wonder where they come from, because it's not the letter before claim. Because, for example, they've got the booking references, they've got the EX.
We don't have the PDF that's attached to that email, do we? Well, the email of the 24th of April has a PDF attached to it. Do we have that? For all I know, it's got all that information in it.
Strange enough, what I have following page 169 is a copy of Bot and Ryanair. But I assume that's not what that PDF was.
My lord, the reason you've got the Bot and Co reference is because this letter appears as an exhibit to a statement, and it's just part of the exhibits to that.
Yeah. What I wasn't sure about when I was asking my questions earlier about whether, if it is said that because of the defect, what was done on the 11th of April was not the submission of a claim compliant with clause 19.6, because it did not enable EasyJet to identify, for example, who the claimants were or tie them up in their system. I asked you the question about whether that was made good by the letter of the 24th of April, the email of the 24th of April, or something else. And it just appears that what this letter does demonstrate is that at least by the 2 days later, on the 26th of April, EasyJet had made the connection.
Yeah.
And your claim was issued, as I understand it, more than 30 days after the 26th of April.
Yes.
And I thought one of your arguments was that clause 19.6 has been complied with.
So it had. So
Because the combination of the attempt to use the portal plus the information provided to EasyJet thereafter was sufficient to satisfy clause 19.6, and you waited 30 days for the claim to be resolved.
So, my lord, that was actually what I was going to come
Right,
to.
okay.
And so that was simply it saying.
But that's got nothing to do with the bit of the text at the bottom.
No, but just that was just the first point about that, and then
Right.
actually I submit that at this point of the 26th of April 2021, the respondent had all the information that required, and having said it was previously unable to locate my client's booking information, it has been able to do that, but then it still rejected the claim, and so then my client has waited, I think it's 28 days, and then issued the claim in the civil proceedings. So I submit that actually, by this point, had this letter been before the court, and it should have been before the court, it was just simply missed, this would have shown that actually a claim either was made or there was sufficient to be able to match up the booking information. So clause 19.6, I submit, has been complied with. And then after having complied with clause 19.6, then my clients had to wait, I think it's 28 days under clause 19.6 to then issue proceedings, which they did. Thank you. So I submit that those are 2 points as to why this letter should be adduced, and then I know that you've permitted the other side's skeleton arguments, and just as I was saying quickly about that concludes my client's application to adduce fresh evidence, but we know that in paragraphs 33 to 34 of the original skeleton, that of August 2022, the respondent purported to introduce data that it extrapolated from the form, and did so without having applied for permission to do so. I know that my learned friend has recognised that point. And I also submit that and as I've said, no application for permission to rely on this evidence has been made. The three limbs of the test, I think they've been outlined, but coming to the first limb, had the respondent been reasonably diligent, they would have been able to obtain the form for use at trial from the respondent's own skeleton. The original skeleton, we know that the respondent had stored the data that had been input into the form and had access to such. In relation to the third limb, so credibility, the data that had been reportedly extrapolated, I submit, is not credible. It's not shown to be from the form, the data set itself, nor is there any evidence in the form of a witness statement from the technician who would have undertaken, the onerous task of extracting the data. And then building on this part of credibility, I would say the respondent has consistently changed its argument. Initially said there was no direct submission. Then
Sorry, I've lost the track. You have to satisfy these tests to adduce your evidence. And I thought your witness statement in support accepts that this was available to your client.
Oh, it does.
It makes the point that it's credible.
My lord, I'd moved on to the respondent's evidence that they'd included in their skeleton. That was all that I was dealing with quickly. So I've said the letter that we seek to adduce is, in relation to reasonable diligence, it was there before trial, but we missed it.
But what does saying that they've been bad add to your application?
It doesn't.
Right, okay.
And then I can conclude my submissions if I may.
Yes, all right. Well, thank you very much. Mr. Clement.
The Lords, in 2019, the court found that Bottom Co were making £100,000 a month by dealing with late flight compensation claims. the response in the Bottom Co case, and indeed in this case, as to why claims ought to be submitted through an airline's claim system, is because that ensures that the consumers, the passengers, in the event of a delay which is not defendable on the basis of extraordinary circumstances, gets all of the compensation that they're due. In the Bottom Co case, we know that 25% of whatever compensation was payable went to the claims handler, in addition to a further 75 or I think £95 fee. So in a compensation claim worth only €250 under the regulation, more than half would go in fees to claims handlers. It's unclear whether the appellants in this case have any idea that this case is still proceeding in their name, because without admission of liability, EasyJet paid €500 to the claimants, to the appellants now, for the flight delay prior to permission to appeal being sought or granted. And that payment was rejected by Lovett's because they said, you have to pay our costs. Despite having lost, of course, the second appeal and being subject to a modest cost order, Lovett's wanted at that stage to claim £8,000 in costs for the claim that they had pursued before the deputy.
Now, I'm not sure I'm alive to this. Where do we find this? Maybe my fault.
No, there's no reason why you should know that, because the papers aren't in the bundle. But I do have a clip of the relevant correspondence, if that's helpful. But I thought that it's important for the court to know what the real context of this case actually is. This isn't about two passengers who were delayed on a flight between Italy and one of the nearby islands, not receiving their compensation. They've had it.
But these submissions will be relevant on questions of cost at the end of the day.
Yeah, they may well, but I think, I said in my skeleton that context is important, and I set out some of the context about this being on the small claims track. I think the context about this appeal is also important, because we wouldn't want your lordships to proceed under the misapprehension that EasyJet are wrongfully holding on to compensation.
Well, but you say that. We haven't heard you yet on the letter of the 26th of April, but on its face, by the 26th of April 2021, EasyJet knew that two passengers travelling from Milan to Alghero had been delayed by a time that would entitle them to €250 compensation. They had located them on their system, and they rejected their claim because of an alleged failure to comply with Article 19.6. I mean, that. Why was that done?
Because
if you're making broad merits-based points,
because if it's accepted that the conditions in the terms and conditions are applicable, and that is accepted by both appellants and respondent, then this is an issue about whether one can subvert conditions precedent. And
but you're saying, I thought you started by saying that you introduced this system to ensure that customers get their compensation, and you're now using failure to comply with 19.6 in this case to reject their claim.
That is always why this claim has been rejected. As your lordship saw from the defence, it wasn't rejected on the merits of whether they were on that flight and whether that flight was delayed and whether that was whether the statutory or the regulation defence was available. It was rejected because they hadn't complied with the contract. And the contract, I'd like to look at clause 19.6 in a little detail, but it won't take very long. It's not a very long clause. But it's not been defended on the fact that these weren't passengers, or that they weren't passengers on that flight, or that the flight wasn't delayed, or that there was the exceptional reasons defence. It's been defended entirely on the basis that they didn't comply with the condition precedent 19.6.1. And
it's perfectly clear that there is more to this case than payment of the compensation to the customers. Nobody in their right mind comes to the Court of Appeal for €250.
No, it's absolutely about whether airlines are entitled to rely on the terms and conditions that they have that have been already considered by this court in Bot & Co, and whether they can rely on a completely automated system. Every communication from the airline has said, we can't find your booking. Please give us the information and we'll deal with it.
Well, it said that they couldn't trace evidence of the contract, any contact made directly, even in that letter, the 26th of April, when it's perfectly plain that they knew exactly who they were dealing with.
Yes.
And indeed, they'd been provided with the email reference 2 days earlier.
Can I just address that point? Your Lordship said that several times, and I've failed to identify why Your Lordship says that.
Page 169, EasyJet were provided with the reference that was on the email that came back, the generated by your system.
Yes. So that reference number has nothing to do with the flight. That's simply
No.
Every time you go into a computer, it generates another number.
But you would have been able to trace, using that reference ID number, the submission that was made.
Yes, I think that's right. And of course, we've said...
And yet 2 days later, you say we can't trace evidence of any contact. They'd given you the number.
I must say, everything that appears before the heading response strikes me as an automated response, which has not had much human thought, if any, applied to it.
We can look at the pleadings, we can look at the witness statements. None of it has had much human endeavour applied to it. The defence refers to a Bot & Co claim. The particulars of claim say this happened at an English airport. I mean, it's rubbish, all of it. And that's why the context of this small claims jurisdiction is important, because the volume of these claims is huge. There are delays all the time in the airline industry, which are not excusable under regulation. We can't have a situation as an industry, whether on the consumer side or the airline side, where there's got to be hands-on. It's got to be an automated process. That's the only way to make it efficient, and it's the best way of ensuring that consumers actually get the money to which they're entitled. And so if you put, let me take it to the sort of absurd position. If you put rubbish into the online form provided by most of these airlines, are you entitled then to say, we've made a claim and now we can sue you? And the answer to that question surely ought to be, of course you can't. You can't write in Mickey Mouse and any old number and then say, well, we've put in a claim and you didn't respond within 28 days. And for better or for worse, the passenger locator number, known on the sort of client-facing side as a booking reference, is the mechanism by which the entire industry locates its passengers, the clues in the name. And the overwhelming reasonable inference seen by every judge below this court is that the booking reference number was not accurately put in the online form. And
well, that seems
the deputy
pretty
district
clear.
judge was perfectly
Pretty
entitled.
clear at the moment. I mean, the deputy district judge seems to have cottoned onto that, and it seems pretty clear at the moment to me that is what happened.
I'm a learned friend.
But why then doesn't your automated response say you've given us the wrong booking reference?
Well, maybe it doesn't know which bit of the information is. I don't know the answer to that. There's no evidence.
Well, you just said that the passenger locator number is the key thing. I mean,
Well,
the passenger locator number will tell the airline everything it needs to know. It will tell the airline who the passenger was, what flight they were on. The airline will know that that flight was late. What more does it need? I mean, I can see that maybe requiring the passenger to put their name and contact details in may make sure that the payment goes to the right person. But in order to identify whether there is a valid claim, the one piece of information which the airline needs is the passenger locator number.
Correct. I think that's correct. I mean, we have no evidence of that, but as it happens, I think that would be a perfectly reasonable inference to draw.
Yes.
The passenger locator number is a slight misnomer because that doesn't identify every single person. So if you or I booked a flight for 4 people,
Yes.
then one would receive a single booking reference number on the client, on the client-facing side, and a passenger locator number. So we've all referred to one form or data set here. There would have had to been 2 anyway, because there are 2 passenger locator numbers, as we see in that letter.
I thought one passenger can submit a claim on behalf of the other passengers on the same booking.
On the same booking. So if your lordship happened to have a family and had booked a flight for, say, 4 people,
Right.
And you were the person who'd done the
You have to
booking.
fill in the online form 4 times.
No, you would not. That's the point. You would only have to fill it in once for those 4 people. If Lord Justice Mayles and Lord Justice Snowden went onto the website and booked your own tickets to go somewhere, then each of you would have to fill in the form. That's the point it's making.
And there are 2 booking references on the 26th of April letter, aren't there?
Correct, for the two
One
different
ends
passengers.
2v3 and the other ends XNX.
Absolutely. Yeah. And those are the numbers that we see on the boarding cards.
Yeah. How did your system know that those were the correct passenger locator references to use in that letter?
I don't know the answer to that. I don't know whether the boarding cards had been produced by that stage. I'm sorry, I just simply don't have the evidence to answer that question, or indeed the instructions.
I mean, one of the curiosities is that the data that your predecessing Queen's Counsel, King's Counsel provided in the skeleton has the right booking reference, has a correct booking reference on it. It's just not the one for Paolo Dore, it's the one for the other person.
Well, what your lordship may also have noticed is that it's not the same reference number that everyone's been talking about, the 17. Exactly.
But it is an accurate booking reference.
Yes, I mean I have been very recently instructed. When I saw that, I didn't think it was going to help very much in any direction.
I hadn't spotted that.
So it may be that these forms could be simplified, and one could provide simply the booking reference number and the name and the bank details, and that would populate everything else that needed to be populated.
I mean, in a way, the airline doesn't even need the claim to be made, does it? Because it knows which flights were late, it knows which flights it doesn't have a exceptional circumstances defence, it has details of all the passengers on that flight, including knowing how they paid for their tickets, so it could simply pay them the money.
The regulatory regime, that's true. The regulatory regime is not an automatic compensation regime.
No.
And the airlines, all of them, not my client necessarily, but all of them rely on the fact that people have to make a claim in order to pay out. And I imagine there is a formula somewhere in the back office of every airline about a percentage of claims that are made and percentages that are not.
I'm sure there is.
But we don't have a regime where if a flight has been delayed and there are no extraordinary circumstances, and that is the extraordinary circumstances debate is fortunately one we don't have to have, but it's what causes most of these claims to be fought actually.
Yes.
When they get to trial. We don't have a regime where it says, right, we can see on the passenger manifest there were 200 passengers, we know there's no defence under the regulation, here everybody here's your money. It just doesn't work like that.
So, have I just going back to one of Lord Justice Birss's question? I hadn't picked this up at all. It looks like the error may simply have been a transposition of the booking reference number with the passenger name. In other words, Miss Dore's booking reference number has been put onto the other traveller, Miss Pistada, and vice versa. So, I mean, if that's right, that's another explanation.
Well, we would all be speculating. I mean, I honestly don't know how to answer your lordship about that.
Yeah. But certainly by the 26th of April, EasyJet knew exactly who the claimants, and I'll use the expression in inverted commas, were, and they had been told they did use the portal. Here's the error message and the reference number.
Yes.
And you say, in those circumstances, the use of the portal incorrectly provides a defence under 19.6.
Means that you did not directly give us your details and allow us to deal with them.
Well,
So that's the. Can we have a quick look at clause 19, because I think it might be.
yeah, which clause 19 are you going to ask us to look at? Because there are two that have been put into the bundle and they're not the same.
Yes, it's not very helpful, is it? But I think it's because the terms and conditions recently changed almost the day before this particular one.
And there's an interesting difference.
Well, the version I've been using is at page 137 of the bundle.
Yes, that's not the correct one. I mean, it's also unhelpfully cut off at the top of the next page.
They all are, yes.
But that's not the correct one, is it? If you look at page 153, the wording that your clients recite, it's the last sentence. Claims may be submitted using the online form here.
Well, I don't think that I think I'm right about the terms and conditions that apply, and this letter was, as Lord Justice Mayle suggested, perhaps not overly furnished with human input, and refers to the old terms and conditions. So I am confident that the terms and conditions that I referred to at page 138 are those which have been in application since May 2021 and still are.
Even though they appear to have the November date on them.
And even though they're not the ones that your clients pleaded in their defence.
Well, are they not?
No. If you look at page 119, which is your client's defence,
That's 6.5. Passengers must submit claims directly to EasyJet.
yeah, but claims may be submitted using the online form. That's permissive.
Yes.
Doesn't say they must be.
The only disadvantage of doing everything electronically is that I'm having to jump backwards and forwards. No. Perhaps I just ask my learned junior, who's been involved in this case longer than I have. Okay. Right. Well, I think I'm being told that the terms in the defence are the correct terms. They were the ones in force at the time of the booking.
Yeah. Right, so even though the claim was submitted subsequently,
Yes.
Claim was the portal was attempted to be used 2 years later.
Yes.
The terms and conditions applying to the compensation claim that was said to restrict the access to compensation claim with the original earlier, of which, i.e. this one. Yeah.
Yes, I
That
think
makes
so.
sense.
I think so.
Right.
That makes two important differences, doesn't it? One is that the word may is rather different from the word must. And the second is that whatever we decide will be by reference to terms which are no longer in force and therefore is going to be of limited use to anybody.
Yes. That is the answer to both those questions.
Yes, right.
I mean,
Okay.
the current wording simply doesn't, in that sentence, doesn't use the word must. I mean, the word must in relation is in the first bit is the same. It's just the last sentence directing people to the online form. The current wording just says the procedure to be used is here, and
Yes.
in fact you can't see it, but
It's a hyperlink.
it's a hyperlink. Whereas this seems to make it optional to use the online form. As long as you satisfy the first sentence,
Yes. Yes, I mean, I think there's a good argument for tidying up these terms and conditions. We looked at the expression directly before as well, and what that meant. I think actually, to be fair to the airline, that is clearer, made clearer at least by some of the subsequent subclauses, particularly 19.6.6.
Anyway, sorry, before we set off on this journey, I thought at least we better get clear on the terms and conditions we're talking about.
As ever, your lordship's right, but the 1966 says passengers are not prohibited by this section from consulting legal or other third-party advisors before submitting their claim directly to us.
Are we to assume that that is the same in the relevant terms, or do we just not know?
I think I can't be adamant
No.
about that. The whole purpose of this system, and the terms are very similar to the Bottom K Ryanair terms that have been considered by Lord Justice Lewison. The whole purpose is to make this a really easy way for passengers to claim compensation. And Milan and Friend said, well, what could we possibly do? We didn't have the form, we couldn't print it, we couldn't save it. What they could have done is provided a witness statement at trial which said we put our details into the online form and made a claim. And in the witness statement provided by Miss Hamblin, that was not said. And I don't want to skip ahead too much, but the reason why this case is so peculiar is that the criticism made by the claimants, well, what could we possibly have done, throwing their hands up in the air? They could have put their information into the online form themselves. And instead, they chose to go directly to Flightbright, who then chose to engage yet another party, Lovett Solicitors, who, rather than using the online form at all, wrote a letter before claim in 2019. It was only 2 years later that anybody tried to put a claim in to the online form at all.
I understand that, Mr. Temming, but speaking for myself, if I'd done something on the web that involved filling in some web form yesterday, and I was then asked today for precise details of what I've done, the best I could probably do in most cases is say, well, I think I filled it in correctly, but I don't know. I don't have any proof of that. So how can you criticise them for not saying effectively what I've just said to you?
I can criticise them because they haven't said that, and they never put the information in. So the reason they couldn't provide that witness statement, say, look, I'm sure I did my very best, and I think I put in this information, and by the way, here it is that they never actually did it. The
witness statement says the claimant did make a direct submission on the web portal, which was perfectly true.
Sorry, I missed the beginning of that.
Miss Hamlin's witness statement says that the claimant did make a direct submission using the defendant's web portal. Now, you can take the point, which I understand, that maybe it wasn't actually the claimant, it was actually somebody working for Flightbright. I get that.
That is the point I was making.
Well, no, I didn't think it was. I thought the point you were also making was that they didn't assert that they had filled in the form correctly.
It's actually the former point that I was making. That
right.
It's not true that the claimants...
Well, I understand that it's not true that it was the claimants themselves, but Bott makes it clear that the claimants themselves don't have to fill in the form.
They didn't fill it in, and the reason that no evidence was provided on their part saying, we have made a valid claim, here's the information put in, is because the claimants don't know what information.
No, that's why I'm jibbing with you, Mr. Temming, because I understand that the claimants didn't fill in the form themselves. But what I'm putting to you is, even if they had, they still wouldn't have been able, like most normal people, to have said what they'd done on a web form, which didn't allow them to save the form or print it out or do anything. But then afterwards, they're in no worse position for the fact that they had an agent do it for them.
Then let's look at the trial process in the small claims court in front of the Deputy District Judge. He'd be presented with that evidence from a passenger saying, look, I went to the web form, I filled it in as best I could, I got a strange email back saying we can't find you, I decided I couldn't be bothered with the process, and it's a matter for the District Judge at that stage to say, well, all right, I accept what you say, I accept that you made a direct claim to the airline, you filled in their web form, and they've failed to respond. And the airline could live or die by that. And say, all right, well, fair enough. We haven't done a deep trawl of our data set to try and find out what you've done, what's gone wrong, and all the rest of it. We haven't engaged our IT department to go and
Hang on, it's hardly a deep trawl. It's basically, you know, the flight that was delayed. Nobody doubts which flight this is all about. There's only a limited number of people on the flight. There's only a limited number of claims made in relation to that flight. How much of a deep trawl is it?
no idea, and certainly neither is your lordship.
Well, sorry, you asserted it was a deep trawl. I'm jibbing it that it's a deep trawl. If the maximum number of claims you could possibly have on your system is what, 300 for an airliner of this?
For that flight, it's not. That's not how the. I mean, we don't have evidence about how the database works.
You mean the database doesn't? It isn't interrogatable by flight.
I haven't got any evidence about that. I don't think.
Okay, well, for me to. Okay, but in which case, I mean, saying it must be a deep trawl, I think, is, with respect, giving some evidence, isn't it?
Well, it may be.
I'm sure airlines collect data about people who use their services all the time. That's very valuable information. The idea that they're not able to interrogate their system to find out who was on a flight would be an inference I wouldn't be prepared to draw.
No, I'm not. I mean, I wouldn't be suggesting that. First of all, the passenger location number is the primary piece of information that airlines use to find out about who's been on a flight and what have you. But we're looking at completely different things. There's a booking system, there's a complaints delay compensation system, there's masses of data that people hold on all of us.
It's perfectly possible that claims were made, two separate claims were made with the correct passenger locator numbers and the correct names, but just transposed.
That is possible, yes, but the Deputy District Judge was not convinced about that and said, you haven't convinced me that is what you did, or that you put in sufficient data.
But for the reasons my Lord Justice Birss put to you, how realistic is it to expect somebody who can't save the information that they've inputted into the system to be able to identify the error which has generated the email back if you don't give them that option?
All that had to happen was for the claimants, the passengers, to say, this is what I did. I filled in the web form with my data, it was correct, and they've refused my claim. That's why we're here.
Well, they did say, we put in a claim on the web portal. I mean, they didn't say which was correct. I mean, it would be, that's the inference.
And it was untrue that they had done it, but yes.
Well, somebody did it on their behalf, but Bot makes it clear that somebody else can help them fill in the form. The only requirement of 19.6 is this word directly. And I thought Bot made it reasonably clear that somebody else can populate the computer fields on the form for the claim, the customer. The only thing this is trying to stop is people using solicitors or some claims firm by another route, other than by the portal. But
it's more positive.
It's not saying, as I read Bot does not say somebody else can't fill in the online form for you.
No, you can get that from paragraph 72 of Bot. But one also has to look at the terms and conditions, which say, which set out who, 19.6.2, and I'll just have to cross-check that against the defence, but bear with me just for a moment. It says save is set out in 19.6.3 and 6.4 below, which was for people with effectively with disabilities. We will not process claims submitted by a third party if the passenger concerned has not submitted the claim directly to us and allowed us time to respond.
Yes.
So that may be a slight gloss on the Bot terms and conditions, and indeed on what Justice Lewis said about.
But is your contention that a passenger cannot engage the assistance of somebody else, whether for free or for reward, to submit the claim on your portal?
I'm not going that far. All I'm saying.
Well, you can't, because you don't know who's
exactly
been at the keyboard.
Exactly, and so that would be it would be unworkable to have that sort of provision. All I'm saying.
So the fact that the claimants in this case used Flightwright or whatever the company is called, or the solicitors here, Lovetts, to enter the information on the 11th of April 2021 is a complete red herring. Somebody entered the information on behalf of the claimants, and
it makes it more difficult for the claimants then to say we put in the right information. And indeed, when they can't positively assert we put in the right information, and when all of the evidence suggests that they did not put in the right information, and they got an email back, an automated email back saying, we can't find that you on that process, that's good evidence that they did not put in the right information.
Well, you had found them by the 26th of April.
Yes, but we're not dealing with the 26th of April. I mean,
With respect, you may well be, because by the 26th of April, something had been put into the computer system. You'd been given the identification number that the computer system generated, and you wrote back clearly having identified the two individuals concerned by their passenger locator number, but saying, nonetheless, we can't trace you as having done something on our system. That's why we're rejecting.
yeah, it's infelicitous wording, but what it says is effectively the same as it's been said all along. On the online portal system, there is no data which matches passenger, flight, booking reference. That's what it says.
Well, there was data that matched passenger locator number, flight, and what was the other one you said?
I can't remember.
Okay,
Maybe.
but the possibility is that it's just the names were the wrong way round, for example.
Yeah, and then in an automated system, when you put in wrong data, computer says no. I mean, you know.
And so the question that my lord raised right at the very start of this hearing is, to what extent can you have a computer system which says no if you don't get everything exactly right? Is that a material restriction on the right to compensation outlawed by Article 15?
I accept that. That's a perfectly reasonable and rational question to ask. I mean, and that is exactly, actually, what Millennium Jr. said at the first instance trial before the Deputy District Judge. We've got the transcript where he said, this is what the issue here is. Did they put in the right data into the form? Did they put in the form with the right data in it? And as my learned friend said in her submissions, both before the circuit judge, and I've quoted, taken it out of the transcript and quoted it in my skeleton, it was accepted by my learned friend that it's important that the fields are filled in and filled in correctly, quoting my learned friend. And so if it's accepted by the appellants that it's important to fill in the form and fill it in correctly, the overwhelming preponderance of evidence here is that they did not, and in those circumstances, this is the result. Now,
Even if correct. Sorry.
No,
I'm waiting to see who goes first.
What I was going to say with Terry was, the reason why, at least speaking for myself, I don't have a huge amount of sympathy for that submission at the moment, is because it elides two possibilities. One is that a minor error took place, and one is that a major error took place, and we just don't know. And if there is a potentially perverse incentive in the way that your clients are arguing the case relative to their system, because they could just always turn down anything for the most trivial error, which wouldn't in fact cause any genuine difficulty for EasyJet. And because we don't know, we can't tell whether in fact the material that was submitted was almost all correct, but there was some error, like a spelling error in somebody's surname when everything else was there, which any rational person looking at it would say, well, that's fine, I can still identify this, there's no real problem. And if your client's system had sent back in its email, this is what you sent us, and we have a problem with it, then at least we might be able to answer those kind of questions.
Yes,
But
I
we
think
can't.
that's fair.
And and to be, as Ms. Cochrane's submissions come down to on her second final point, you hold all the cards.
We don't hold all the cards. In fact, the passenger holds all the cards. The passenger knows what their name, flight number, booking reference is. And if they give us junk, and we can't therefore identify them, find them, how is that our fault?
Yes, but if they don't give you junk, if they give you something which is almost completely correct, bar one trivial mistake, how do we know your computer didn't reject it?
We don't, on the basis of the evidence we've got. But on the basis of all the evidence we've got, it looks like it wasn't a trivial error. It wasn't the missing A from Ms. Pistida's name. It wasn't the use of a capital letter rather than a lowercase letter. It was a fundamental piece of information that was wrong, and that was the booking reference number.
But there is nothing to tell the passenger that that is the key thing it must get right.
That's true.
I mean, if it did say that, you know, we can cope with minor errors, but you must get the booking reference right, otherwise our computer can't cope.
Yes.
That would be one thing, but there's nothing
My lord,
like that.
I agree, but we're looking at an industry which carries millions of passengers a year. and these forms are designed to be as simple as possible. They're catering for the lowest common denominator, particularly in low-cost flights where people perhaps aren't used to flying. If you start saying, here's a form, get it as close as you think you possibly can, it's going to be a recipe for complete disaster. What it has to say is, give us the information, and what no court has been shown or given. And I don't think any blame can be levelled at the airline for this, is exactly what the form requires, what the margin of error, if any, is permissible in the form.
But I mean, we do know that people make mistakes. That's what people do.
We certainly do.
And the problem is either or both of the fact that they're not told that the booking reference is absolutely key, and they're not, as my lord says, told this is what you sent. It appears to be wrong because our system can't trace you.
Yes, that's true. But and what I don't know, and we would all be speculating, is whether if one put in rubbish. I mean, I've used Mickey Mouse. I've taken his name in vain twice now. But if one put in Mickey Mouse, and that because there's a submission, it generates a reference ID in some computer system somewhere. I don't know to what extent it's possible for the computer to work out what's wrong. And frankly, if it could work out what's wrong, then it ought to be capable of sort of self-correcting. And so I think it's a reasonable inference to say it can't work out what's wrong. If you put rubbish data in, you get a rubbish response back. And it's not unreasonable in the context of this industry for the requirement for a passenger to put in data which enables at the stage of submission the airline to tie up all of the relevant details.
Is my Lord Justice Birss's point that it may be perfectly reasonable for the airline to require the locator number, the name, and the other information to be required, provided that, given that people make mistakes, if there is an error and your system doesn't accommodate it, it gives somebody a readout of what they've done so they can check whether they've made the correct entry. Nobody's asking your computer to develop intelligence to figure out what the mistake was.
Yes.
But you've created a system which apparently rejects, as far as we can see, any submission which has an error in it without allowing the passenger who has to go through it the means of checking what it is they put in to create, which is in error.
That's true.
And the question is whether that system is a material inhibition, or whatever the expression is, to getting the compensation to which they're entitled. Because if the design of the system has the characteristics that you suggest, it may well, as it were, be too onerous because it doesn't allow for human error.
All of that sounds completely fair enough, with respect. But and if we were looking at an inland revenue form, which was 50 pages long and might have appendices for different income sources and all the rest of it, one could have some sympathy for that. There are tiny pieces of evidence that were requested in the email, the automated email. Name, flight details, booking reference number. It didn't even ask for resubmission of the bank details or anything like that.
All the more reason you can just feed it back to the person who's misentered it.
Well, I mean, I'd say rhetorically, come on. I mean, what else do they need? They've only been asked to put in 4 pieces of information.
Well, I think we're after 1 o'clock.
Sorry.
We better draw. Pause for breath, and we'll resume at 2:05.
Very well. Thank you.
Short break. If I put 5